Well, good day. My name is Kim Moody, and I'm your host for In the Mood with G C Moody podcast. And today is July the 23rd, 2026. I'm a little proud of myself. This is roughly a couple weeks since I last reported a podcast, and so I'm going to pat myself on the back here a little bit. But today's topic is kind of reserved for the tax geeks, but it does have broad interest, which is the trust reporting rules. And the reason why it has broad or should have broad interest is because these rules cast a pretty wide net, and I'll try to explain that during the podcast here. Unfortunately, a lot of Canadians just get frustrated with this stuff and realize how complicated it is and tune out. So I'm going to start with a little bit of history and context, and just start off by letting you know that I did write a Financial Post piece on this. For new listeners, I do write a weekly Financial Post column on taxation. It's not a very technical column. I purposely try not to do that. That to me is one of the easiest things you can do as a tax practitioner, is write a very geeky tax column. But what I like to do, including these podcasts, is to try and put it in a little bit more plain English and make you understand, or not make you understand, but help educate in terms of the history and context and the importance of tax policy. So with that, what are we dealing with here? Well, we're dealing with the trust reporting rules, and they were first proposed in the 2018 Canadian federal budget. And back then, that's 8 years ago now, Canada was perceived by its peer countries in the OECD to be behind on certain transparency reporting. And it goes beyond tax as well. There's, financial action task force stuff going on, and money laundering, anti-money laundering reporting. And so there's a whole big push around the world for transparency. And trusts got caught up into that net many years ago, especially in Europe. And Canada, back in 2018, 2017, hadn't really reported any kind of, required any kind of reporting of its beneficiaries of trusts and who created these trusts and what have you. Whereas in certain other countries, especially in Europe, there was trust reporting rules. In some cases, there's beneficiary registries, and Canada just had not gone that far. So that's a little bit of the background as to why Canada introduced these rules. It was kind of pressure from other countries to get this up to speed and try to catch up. So 2018, there is a proposal in the budget that they're going to require trust reporting rules, where ultimately the beneficiaries of the trusts would need to be reported, the creators of the trust, or the so-called settlers, would need to be reported, and the trustees would need to be reported. And this caused a bit of a, holy cow, that's going to be a lot of work. But thankfully, when the draft legislation was released in July of 2018, there is some technical issues there that seemed to cause some issues. And at the time, I was the co-chair of the Joint Committee on Taxation between the Canadian Bar Association and CPA Canada. And this is an area of particular interest for me. So of course I took the lead in looking at these rules, and was a contributor to the submission that we made to the Department of Finance on some of the issues. And they're fairly technical issues, but at the end of the day, one of the things that we, not we, the Joint Committee, but we, the practitioner community, and me personally, I was not surprised that bare trusts were not included in that reporting. And why was I not surprised? Well, because for decades and decades, bare trusts were not considered taxpayers for pretty much all purposes of the Act. And why is that? Well, to put into plain English, bare trusts, you do have the indicia of a trust. It is a trust. You have separation of legal title from beneficial ownership. So for example, if Kim Moody opens up a bank account for my mom, so Kim Moody is on title, but the true beneficiary of that bank account is my mom. Well, that's a classic bare trust because, well, first of all, it's a trust, which I won't get into the definition of a trust here because that is reserved for trust lawyers and it needs the three certainties under trust law. That could be a whole podcast on its own, but it is a trust, it's a legal relationship. But ultimately, where you have a bare trust, the key difference between a bare trust and, say, other types of trust is that the trustee, the person who's holding title on behalf of the beneficiary, in this case, I'm holding title, Kim, on behalf of my mom. If it's a bare trust, then I accept and must act on from the instructions of my mom, the beneficiary. Whereas in other trusts, it can be different. Like a classic so-called family trust, if the trustees have full discretion, well, the beneficiaries can give all the instructions they want. But if the trustees have full discretion or discretion period, then that's very different than a bare trust. Whereas because the trustees do not have that discretion, they accept instructions from the beneficiaries. And so to go back to the history here, the bare trusts were excluded from the first version of the rules. Now, again, not surprising because the Income Tax Act, and for those who are watching on YouTube here, this is the Income Tax Act, and I have it open to 104.1. And I'll just read to you what's been in the Act for years. It says, in this Act, a reference to a trust or estate shall, unless the context otherwise required, be read to include a reference to the trustee, executive administrator, liquidator, etc. But, except for the purpose of this subsection, and then it goes on, a trust is deemed not to include an arrangement under which the trust can reasonably be considered to act as agent for all the beneficiaries under the trust with respect to all dealings. Okay, so what does that mean? In plain English, if you have that arrangement that I just described, Kim holds title for a bank account for my mom, and mom gives instructions to Kim as to what to do with those monies, well, that's a so-called bare trust. The Act that I just read doesn't use that phrase, bare trust, but that's exactly what we have here. We have a relationship or an arrangement under which the trust can reasonably be considered to act as agent for all the beneficiaries. So that's a classic bare trust arrangement, right? Separation of legal title, because Kim holds title. Mom is the beneficiary of that. And mom gives instructions. So really, Kim is acting as agent for, it's reasonable to assume that Kim is acting as agent. In that scenario, that's a bare trust. So back to the history, 2018 rightfully excluded bare trust, and they didn't even need to say that. It's right in the Act, right? And so the Joint Committee and other practitioners were at least relieved that bare trusts weren't included because bare trust arrangements are very, very common. As hopefully you could see with that simple example here, Kim holds title on behalf of mom. How many of those arrangements can you think of in even your own family situation? Well, probably a lot, right? And so, like for example, if I am on title for my son, in order to get a mortgage, so I get the mortgage on this property that he buys, that he's ultimately the beneficiary. Is that a bare trust arrangement? Well, it might be. And so you need to look at things like that. And so fast forward to 2022. First, well, I guess I missed a bit of the history here. When these rules were proposed in 2018 federal budget and draft legislation in July of 2018, they were first proposed to be effective for the 2021 taxation year, which that in and of itself was a bit odd, right? And I say that because it's a little odd to introduce tax legislation with an effect of, 19, 20, 21, 3 years later. And actually more than that, 3.5 years later. So that was a bit odd. And so a lot of the tax community pretty much took the position, yeah, wake me up when it's over. And so in the meantime, I was very concerned about these rules. A number of other tax practitioners were too. And so we started ringing the alarm bells. But again, the overall response was, wake me up when it's over. Fast forward to COVID, of course, and this became a low priority for the government. To a certain extent, I can understand that. And so they deferred the implementation to 2022. But concurrent with that, what happened was they made some further amendments to the draft legislation, and bare trusts were now included. That was one of the amendments. Is like, what? Are you kidding me? So the Joint Committee, I was no longer leading the Joint Committee at the time in 2022, but the Joint Committee rightfully pushed back on this. A whole bunch of other organizations did too, and said, listen, you're going to cause a bunch of problems here with trust reporting if you require bare trust. And so we respectfully suggest you drop it. Well, the government didn't listen, and they deferred implementation one more year to 2023. And as the tax community who has experience with this knows, the 2023 filing season was a total gong show. And why? Well, because I think of a foundational problem. And I wrote about this in my Financial Post article in June 30th of 2026. You can Google it, you'll find it. But I think the foundational issue, there's a number of problems here, but the foundational issue is that in order to get caught into the trust reporting rules, the trust doesn't need tax payable. You just need to have a trust relationship. And if the trust relationship, legal relationship, meets certain criteria, then you got to report, regardless of income, regardless of the fact that there's no tax. And if you don't file, then you could be subject to significant penalties. And so the starting point is determining if you're dealing with a trust. So if Kim Moody has a joint account with his wife, joint bank account, is that a trust? Well, I can tell you probably not. But it does raise the question is, what about all these other legal relationships? There's partnerships, there's trusts, there's co-tenancy arrangement, there's joint tenancy, there's joint with right of survivorship, and the list goes on here. But how do you determine whether or not you're dealing with a trust relationship as opposed to all of those other legal relationships? Unless you're very experienced, that is exactly the domain of lawyers. Lawyers go to law school to learn about the distinctions between various legal relationships, including trust. And to be fair, many lawyers in law school, or law students, they just scratch the surface on trust. And some don't take trust law at all. But they're no dummies, obviously. They certainly can figure out what a trust is, what the statutory requirements are, and what the common law requirements are, the three certainties, for example. So unless you have a lot of experience in this area, which most tax preparers don't, that's a real struggle. If you're dealing with a common situation, Kim is on title for his son, Lucas, this is a real life example, is that a trust relationship? Well, you got to dig into it a little bit further and figure out. And so if it is, you may have trust reporting. But if it's not, then you're probably okay. But do you want to chance it? If you're not certain, like if you're not a lawyer and you're not very experienced in this area, what do you do? Like if you're an average accountant with decent enough tax knowledge, but you're not a lawyer and you're not trained in the fine distinctions in legal relationships, what do you do? Well, and that was the real problem in the 2023 filing season when accountants and tax preparers were filing trust returns. And so the CRA, to their credit, was noticing the interpretation problems because their phone lines were lit up. But there's only so there's only so much effort that they can put in on a quick basis. And so at the end of the day, practitioners were screaming, taxpayers were screaming, and the CRA decided to defer, because they do have that administrative authority to do this, to defer the filing for trust reporting. But it was days within the deadline of March of 24, at the end of March 24, which on the one hand is like, good. But on the other hand, it was like, oh, come on, really? After all this effort and all this time that was spent by taxpayers and their advisors, you're now going to say, yeah, just kidding. The amount of effort that was put into that filing season was tremendous. And a significant complicating factor of that was determining, are you dealing with a bare trust? The first premise, again, are you dealing with a trust? But included in that determining question is it a bare trust? Because if it is, then you got reporting issues. And so I can kind of understand why the CRA deferred implementation or reporting requirements, but it was something that the alarm bell had been ringing for quite some time. I'm going to take a little sip here. And so in any event, fast forward to 2024, later in that year, in August of 24, and the Department of Finance, Department of Finance issued amendments to try to make the reporting requirements a little bit less onerous, I guess. In other words, exempt certain types of trusts or certain types of arrangements from the filing requirements. And there was some submissions put forward as a result of that. A year later, there was some more amendments in August of 25. But prior to that, in October of 24, the CRA announced that there's going to be no filing requirements for bare trusts in December for year ends of 24 for trust. So suspension. And they exercised the same discretion for 25 a year later. Fast forward to this material of August 25 was put into a bill in November of 25. There was a few minor amendments that were contained in that bill from the August of 25 amendments. But ultimately, this bill got passed in March of 2026. And now trusts, including bare trusts, are going to have to file again for the 2026 filing season. Now, what does that do? Well, it's going to be, in my view, a repeat of the 2023 filing season. Why? Because the foundational issue has not changed. You've got tax preparers who need to determine legal relationships. Are we first dealing with a trust? And if it's not a trust, what is it? Is it a partnership? Is it a joint tenancy, etc.? What are we dealing with? And so that foundational issue has not gone away. Instead, the new legislation has cast a huge net. So basically all trusts, including bare trusts, have to file. And then what the draft legislation does, as I said in my Financial Post article, is it cuts little holes in the net. And if you're so damn lucky that you as the fish that's being caught in that net can slip through one of those holes, then great. But ultimately, you're going to have to put in effort to figure out whether or not you can slip through that net. And that's the problem with the way the legislation is done. Cast a huge net of complexity, and then further complexity with saying, okay, well, here's the ones that don't have to file. that to me is problematic drafting and problematic. It's a problematic approach. I still stand by the fact that bare trusts do not need to file. I don't know what the CRA is going to do with this information, especially given the fact that bare trusts have been ignored for decades and decades and decades. Rightfully so, in my view, as I read 104 sub 1. So now that it's law, what do practitioners and taxpayers need to do? Well, get ready. I mean, as I record this, we're in July, and you've got August, September, October, November, December, January, February, March. You got 8 months until filing deadlines. So get ready. But I think this also applies to the CRA. The CRA, in my view, instead of scrambling to get stuff ready, help interpretations, they need to start releasing interpretations today to help the tax preparer community and to help taxpayers in general. Now, to that, I'm just going to look at the website that the CRA has. It's called, and you can Google this, you'll find it, Enhanced Reporting Rules for Trusts and Bare Trusts. Frequently asked questions. Now, because this, Bill C-15 was passed, they've updated this website. They updated it June the 5th of 2026. And there's a few interesting updates, and they, to their credit, every time there's some new additions, they highlight it with a blue new characterization. But I think, again, just to re-emphasize my foundational point, right on the first page of the website here, it says trust reporting rules for T3 returns, and it's got frequently asked questions here. First question, 1.1, what is a trust? And it gives common overview of what it is, but it's very thin. And then question 1.2, the very next one. I am not sure whether I have a trust. Can the CRA provide specific guidance that will allow me to determine if my situation involves a trust? Here's the answer. The CRA does not provide legal advice, so it is not able to advise taxpayers about the application of the private law to their circumstances or to interpret trust documents. It is the responsibility of the parties involved in an arrangement to determine the true nature of their legal relationship and whether they give rise to a trust. I can't blame the CRA for that because what they wrote there is true, but it lacks empathy, right? It lacks empathy because ultimately what they're saying, which is right, that they don't provide legal advice. But do you think tax preparers provide legal advice as well? No, they don't. Or they shouldn't if they're not qualified to, because they're not lawyers. And so, I'm not a lawyer, but do I have a lot of experience in this area? Absolutely I do. But do I screw up in this area? Sure I do. And any experienced tax advisor who submits otherwise is fooling themselves, because this is a very, very difficult area for even lawyers to determine whether you're dealing with a trust. And again, that is the foundational problem with these rules, is that it casts a huge net, with the first question being, are you dealing with a trust? And then, of course, are you dealing, if so, are you dealing with a bare trust? And so the purpose of this podcast is not to walk through all the new exceptions to these rules, but to highlight that the foundational problem still exists. And yes, there are little holes in the net that can get you through because of these amendments, but the foundational problem remains. So my recommendation, just to summarize on this point, is 1, get ready, taxpayers and taxpayers, and 2, the CRA needs to jump on this. They need to start releasing interpretations that are common and help taxpayers get ready for this inevitable tax filing season that could be very problematic. Let me highlight one tax practitioner who I really enjoy, and actually I know him personally. He's a super smart guy. His name is Hugh Nielsen. And Hugh, is part of Video Tax News, and Video Tax News put out a session on trust reporting rules, and I'll comment on that in a second here. But but the point being is that there's a lot of interest in these rules, and he highlights some of the complexities here. I'm just going to try to find it here. So here we go. He highlights this, and I think it's a brilliant example, and you can generate tons of these types of examples. He says, because he's responding to one of my comments here, Kim, my recent realization is that no one is actually trained to answer a lot of these questions. For example, if Grandma and Grandpa have opened a single bank account and 2 security accounts for each of their 7 grandchildren, how many bare trusts is that? 1 big trust with 2 trustees and 7 beneficiaries? Or do we have 42 separate trusts, 1 for each grandparent's interest in each account? Something in between? It's a clever question, right? Because you got Grandma and Grandpa that contribute securities to a single bank account for their 7 grandchildren. How many trusts are you dealing with here? How are tax preparers supposed to know that? How are even trust lawyers supposed to know that without diving deep into the facts? And so it's a very good question that Hugh Nielsen of Video Tax News posed. Now, on that point, my good buddy Jay Goodis and I have Canadian Tax Matters, which is a tax education platform as well. And we're going to be doing a session on bare trusts, well, actually the trust reporting rules. We did one a couple years ago, a few years ago now, when these rules first came out, and the interest was huge. I suspect the interest will continue to be huge as well because of what I'm talking about today. Now, just to kind of close on this, some practitioners are saying, well, again, wake me up when this is over. Because, practitioners like me are ringing the alarm bell, ringing the alarm bell on this, concerned that we're going to walk into a repeat of the 2023 filing season. And some practitioners are saying, listen, I wasted so much time last time. I wasn't able to recover all my efforts because clients weren't willing to pay the fees because the CRA deferred. So I'm not going to do all this. And to me, I see both sides of that coin, right? I see the fact that tax practitioners, tax preparers got burned. Taxpayers got burned. On the other hand, it is the law, and like it or not, you got to comply with the law. At least I, in a good society, you should be complying with the law. And so that's kind of the two ends of the extreme here, right? You got practitioners who are very cynical, some that are very worried because they're not lawyers who can interpret legal relationships. And then you've got the other side where, hey, we got to comply with the law here. And CRA, we need you to help be very proactive here to help with the interpretation of these rules. So with that, I think I'll leave it at that. It's a difficult situation. And again, I sure hope that this tax filing season for trusts will be a lot smoother. I'm not very optimistic though, but I sure hope that somehow we can skate through and get this better. In the meantime, if you're a practitioner, get up to speed on these rules quickly. If you're a taxpayer, same. And if you're the CRA listening, help us out as much as you can. We'd really appreciate it. Thanks very much. All the best. Bye now.